his arrest and detention was declared null and void. Similarly, in General Hamunyela case, the applicant challenged his arrest and subsequent detention, and same was declared unlawful. Suffice to state that the applicants in Kasu are not attacking their arrest and detention. The magistrate's court is a creature of statute and not competent to entertain such issues, even if they were attacking their arrest and detention. Therefore, nothing turns thereon. In the case of Amshelelo, reliance was placed on that case, arguing that the other applicants were granted bail. Now, it is apparent that the investigating officer testified that they have considered the role each accused played in the matter, and with regards to the third applicant, with regard to the third applicant, regarding accused 10, he testified that he was busy with the present bail application when accused 10 was granted bail, and he was not at liberty to divulge such information. Mr. Dilungwe, on the record, stated that they applied their mind to the facts and considered the evidence on the record. Therefore, it appears to this court that the state applied its mind, and that is apparent on the record in respect of the third applicant. However, the court is unaware why accused 10 was granted bail. Be that as it may, each case is decided on its own merit. Further, there was also an issue regarding the seizure of the applicant's cell phones. The law permits that under certain conditions, seizure of properties may be allowed. And it was argued that that was done in violation of the accused's rights. Suffice to state that the admissibility of such evidence so obtained will be determined at the trial court. Nothing turns thereon. Now, with regard to the grounds of objections, generally the applicants testified and stated in their affidavits that they will not abscond. They want to stand trial and clear their names and have no intention to run away. It is common cause that the first, seventh, and sixth applicants personally reported to the ACC officers and police stations and subsequently were arrested. The fifth applicant went with his lawyer, the sixth applicant reported to the Windhoek police station, and the seventh applicant reported to the ACC. The second applicant testified that he was in the north about 60 kilometers to the Angolan border, and he could have ran away if he wanted. However, he chose to come even though he already knew through the grapevine about the imminent arrest. The fourth and fifth applicant testified that they were already aware about the investigations and decided to stand trial so that they can clear their name. Therefore, on the record, it is not apparent, there is no evidence that the applicants will abscond. Interference with investigations or witnesses. It was further appellants testified and stated in their affidavit that they will not interfere with witnesses or investigation. They are unaware of the identity of investigations or witnesses. As such, they will not interfere with them. It was the investigating officer's evidence that the risk is there, and he believed that they will interfere with investigations because they did not know then that they were going to be arrested. But now that they've been arrested, he believed that they will interfere. Now, the test with regard to interference with investigation is whether there is real likelihood that the applicant will not may interfere. It is apparent that the investigating officer testified that the applicants are branches of the same tree due to the relationship and that the business entities are registered in the different persons. However, it is also apparent from the record that the applicants have not personally interfered or attempted to do so. Therefore, this court finds on the evidence that there is a very remote possibility that the applicants may interfere with investigations or witnesses. With regard to the seriousness and strength of the state's case, it is apparent that it was contended by the applicants through their counsels of record that the state's case is weak, pathetic, and chaotic, as stated above. They argued it was a commercial transaction and not criminal transaction. The court will not deal with the issue of commercial transaction as it has already been stated above. Neither will the court deal with the issue that the applicant, that Namcor Trading was not a public entity but a private entity, as that issue has been already dealt with. The investigating officer testified that the charges are serious. They involve fraud, a Schedule 2 offense, money laundering, and contravention of various sections of the ACC Act. The 6 applicants stated at paragraph 32 of her affidavit that she does not dispute that all or most of the charges are serious in nature. The second applicant testified that corruption is serious in nature, but the public needs to know the truth and correct facts. Therefore, there is no doubt that the charges preferred against the applicant are serious. Further, the charges herein are economic in nature and involve a significant amount of about 400 million. With regard to public interest or interest of the administration of justice, the applicants argued that it was in the public interest that they should be granted bail. The state case was not strong but just fueled by the media. The truth and the facts were not correct as published by the media. To the contrary, the investigating officer testified with regard to the issue of public interest and interest of the administration of justice that the offenses are serious. The public was concerned and the offenses are of economic nature, which has significant impact on the economy. It was submitted on behalf of the state that it was not, it was submitted on behalf of the state that it was not in the public interest or interest of the administration of justice that the applicants be granted bail. In the matter of Lazarus Shaduka versus the state, it was stated as follows at paragraph 27. Where an accused person has been charged with the commission of a serious offense and if convicted, a substantial sentence of imprisonment will in all probability be imposed. That fact alone would be sufficient to permit a magistrate to form the opinion that it would not be in the public interest or interest of the administration of justice that the applicant be granted bail. In Gepunya versus the state, at paragraph 44, it was stated as follows. The days of distinguishing between the seriousness of monetary crimes and violent crimes can no longer be seen to be different in bail applications. Whether the crimes involve public funds or a physical attack on a member of the society, if the circumstances permit, the seriousness of the offense thereof must be taken into account when considering bail. In this matter, the misappropriation of public funds affects every individual of the Namibian public and needs to be seen for the detectable crime it is. These, together with factors outlined above, are essentially enough to arouse a court to view that the administration of justice does not merit the release of the applicants on bail under the circumstances. In Esau versus the state, it was stated as follows at paragraph 101. In this case, it is a notorious fact that the case enjoys huge public attention before and after the arrest of the accused. The matter is widely and extensively reported on by the media. This is not necessarily decisive that the public has an interest in the matter, because the public might have certain expectations which are not synonymous with public interest. It remains, however, a factor to be considered. In this matter, it needs consideration together with the relevant factors that the applicant, one, and some other co-accused held positions in public offices. In addition, the allegations involve serious charges where huge amounts of public money should have been availed for public benefits and involved. Instead, it is alleged to have been laundered and squandered for the benefit of a few. The evidence alleged that several millions of taxpayers' money is involved, on which there was allegedly tax evasion. That was stated in the case of Esau versus State. As stated above, the applicant faces charges, among others, fraud and conspiracy, which offenses fall under Section 4, Schedule 2 of the CPA. Therefore, Section 61 finds application. This matter, enjoys huge public interest and was widely and extensively reported by the media during the arrest of the accused, in brackets applicant, and throughout these bail proceedings, both in the print and electronic media as well as social media, to the extent that the entire bail proceedings was broadcast live on national television to this date. This does not necessarily mean that the public has an interest in this matter, but may have expectation not necessarily synonymous to public interest. However, it is a factor to be considered together with other factors. The allegations against the applicants involve serious charges where substantial amounts of money were paid to various business entities in which some of the applicants and their associates have an interest, as well as some of the applicants and accused persons in their personal bank accounts. The manner and the speed in which the funds were paid from Namcor Trading to the various business entities, some of the accused persons and applicants, is another issue of concern. It is apparent that some of the accused and applicants were employees of Namcor and Namcor Trading at the time. Further, the court is alive to the fact that a suspect, Malema, has fled the country and the vehicle in question has not been traced. Therefore, taking into consideration the totality of the evidence, even if there is a remote possibility that the applicants will interfere with witnesses or investigation and abscond, it is this court's considered view that it is not in the public interest or interest of the administration of justice that the applicant be granted bail. In conclusion, it is apparent from the evidence of the applicants, to the exception of the 6 applicants, that they contradicted themselves in material respects, both in their evidence in chief and cross-examination, as well as on affidavit and submissions in respect of the seventh applicant. Their evidence was riddled with material contradictions and falsehood. Further, it is also apparent that the applicants also made material concessions on the record, which to some extent confirms the state position. Considering the totality of the evidence, it is this court's considered view that the applicants failed to discharge honors of proof on a balance of probabilities that they are good candidates for bail. The question of bail conditions only becomes relevant once the court finds that the applicants are good candidates for bail. Therefore, notwithstanding that there is a remote possibility that the applicants will abscond or interfere with state witnesses or police investigations, this court is of the considered view that it's not in the public interest or interest of the administration of justice that the applicants be granted bail. In the result, the following is the order of the court. The applicants, that is first, second, fourth, fifth, sixth, and seventh applicants' application for bail is refused. The applicants are to remain in custody. The matter is considered finalized and removed from the road. What is the date? The judgment is available. The court will provide each of the counsels with the copy of the judgment. To both counsels. I'm going to give you the record because I see that the postponements are for bail. I think the other postponement must be. There must be a date for investigations or something. Then the court will then briefly adjourn.
Rise.
Just confirm with the IT whether the machine is off.